Autumn of 1864, in Madison County, Kentucky. The probate ledger preserves the uncle's will, each clause copied neatly, until the final line, "To a bloodline undivided." The words silenced the courthouse. No objections were entered, no attorney's hand corrected the phrasing. Within days, the siblings filed for marriage, and the banns were hurried into the parish book with altered spellings. A page is missing in the chancery petition, torn out before it could be reviewed, and when the twins arrived, the midwife wrote only, "Identical, unfit for witness." From the start, their existence was bound in erasure. What forced a family to hide its heirs behind blank pages and missing names? And why did silence become the only inheritance they left behind? Before we go any further, I want to ask you, where are you watching from, and what hour is it over there right now? Leave your answer in the comments below, and while you are here with us, make sure you subscribe to X Archives so these accounts, sealed, buried, and almost forgotten, can be opened again. The probate record survives as a bound volume in the courthouse, its pages numbered in a clerk's tidy hand. Most of the document follows the familiar pattern: land surveyed in acres, bonds itemized in columns, signatures of neighbors attesting to valuations. But on the final page, set apart from routine detail, the language shifts. There, in ink still dark against yellowed paper, the line appears: "The estate shall pass to a bloodline undivided." It was not a turn of phrase, nor a metaphor. It was a condition, written with precision, requiring kinship to remain whole if the estate were to remain whole. Witnesses in the chamber later admitted that silence followed, as if a hush had settled not only in the room but on the record itself. Attorneys who might have raised questions marked no objections in the margin. Even the clerk, often added clarifying notes, copied the line without comment. The very precision of the handwriting gave the words authority, and the absence of dissent gave them permanence. The siblings, seated together on the bench, understood immediately that inheritance had been tied to action. It was less an invitation than a command, pressed upon them by ink and seal. Probate filings in the days that followed show an unusual rhythm. Petitions that would normally take weeks were moved across desks in hours. Bonds were secured without challenge, signatures collected with remarkable ease. Clerks processed documents with a speed that suggested no debate was permitted. The file grows thicker in those weeks, but not slower. Each sheet carries the impression of inevitability, as if the machinery of law had been set in motion before the will was ever read. Accounts of the hearing note how the siblings glanced at one another when the phrase was spoken aloud. It was not a glance of surprise, but of confirmation. Those present later described it as grim, a shared recognition that the path was already known. Relatives shifted uneasily, but none voiced objection. To speak against the will would have been to speak against the ink itself, against the seal that closed the page. Silence, in that room, became assent. The courthouse volume preserves this moment in unchanging form. The line of inheritance, the signatures of witnesses, the heavy seal impressed at the bottom margin. There is no note of protest, no insertion of doubt. The clause demanded unity of blood, and unity was taken. It remains as stark on the page as the day it was read, preserved not only by law but by the silence that surrounded it. The final page of the will, with the inheritance clause written in precise hand and sealed with signatures. The banns of marriage, filed soon after in the parish register, would carry our own signs of alteration and silence. The parish register for that year contains a line that does not match the rest. The banns of marriage, normally entered in steady, practiced strokes, appear faint and uneven. Letters are dropped, spellings shifted, as if the names themselves resisted the page. The curate who wrote the entry left no flourish, no confidence in the ink. The words sit thinly on the paper, as though meant to fade. Clerks who handled the volume later remarked on the difference. Their notes, tucked in the margins years afterward, described the handwriting as hurried and strained. The deception was visible, but no correction was made. The line was left standing, though it carried a weight of hesitation not found in other entries. Silence preserved the irregularity. The vestry minutes from the following month show a heavy black stroke across the curate's name. Where his signature once appeared, there is only the smear of obliteration. In the margin, a single Latin word is written in another hand: tacit, silent. This was not an accident or a careless blot. It was an official instruction that the curate's role in the banns was to be forgotten. The erasure was not of the marriage itself, but of the man who had written it down. For parishioners, the alteration became an open secret. Those who later examined the register spoke of the oddness of the entry, the faintness of the ink, and the names that looked altered by design. Yet none raised the matter aloud in the community. The parish, bound by its own silence, allowed the union to pass into record without confrontation. Complicity spread not through approval, but through refusal to speak. In the broader sequence of documents, the altered banns form the first layer of concealment after the will. The courthouse clause had demanded the siblings' union. The parish register disguised it. One made it law, the other blurred it into silence. The 2 volumes, preserved side by side, show how inheritance and marriage were bound together through a chain of omissions. The Chancery Court docket preserves the petition filed only days after the siblings' marriage. On its surface, the handwriting is orderly, the margins straight, the seal impressed without smudge. The petition consolidates tenant rights, tithe collections, and parish dues into their control, leaving no space for division. Yet in the center of the docket, between pages numbered cleanly in sequence, one sheet is missing. The binding shows ragged threads where it should have rested, catalogued later by clerks as simply "page absent." The petition itself was approved in unusual haste. Court procedures often allowed weeks for challenges to be lodged, yet this case passed in days. The approval stamp sits firm at the bottom margin, with no corrections, no hesitation in ink. Legal scholars who later studied the docket observed the anomaly. No delay, no appended testimony, no footnote to explain. The silence of the docket carried the weight of pressure, an approval meant to pass without resistance. Tenants named in the petition were transferred on paper without remark. The careful distinctions of ownership that once separated families and plots of land were erased. Entire groups of parishioners who might have raised objection saw their rights folded quietly into the estate's control. No names were struck, but no voices were heard. The Chancery Book became a record of consolidation through omission. The missing page, catalogued without explanation, remains the strongest testimony. Clerks listed it in inventories as absent, yet no search was ordered, no replacement filed. The gap is surrounded by pages of regularity, as though designed to draw attention to what was not there. That absence speaks of something once contested, but silenced before it could be preserved. It leaves the impression of a protest deliberately erased. To the estate, the petition granted the veil of legitimacy. Land, tithes, and tenant obligations were bound to the siblings by seal and docket number, yet for the court itself, the torn binding and missing page leave a record of avoidance. Authority was maintained not through open law, but through careful erasure. The midwife's ledger is the first place the twins appear, though even here they are entered through hesitation. The handwriting, steady in the preceding entries, falters when she reaches the line. She writes a brief phrase, identical, unfit for witness, and then stops. The space where her signature should follow is left blank. This small refusal set the tone for every record that came after. Their lives began in omission. Other births that year fill the parish book with detail, the names of parents, the time of day, the minister's notes. But the twins are missing. The baptismal page turns from one child to the next without pause, as if they had never been carried to the font. The gap remains, more striking than an entry would have been. The parish book tells the story of their absence as clearly as the midwife's ledger tells of their arrival. The midwife's refusal was costly. Within months, her name vanishes from the county rolls. Officials gave no explanation, but her removal is documented in lists of certified attendance. A line once filled with her name now carries only a dash. The erasure aligns too neatly with her refusal to sign, marking the price of standing against silence. She became another omission in the chain of records. Her handwriting on the ledger page is uneven, the strokes lighter, as though her hand trembled when she wrote the line. Archivists who studied the entry noted the change in pressure compared to earlier births. The moment of recording carried her protest, not in words, but in the refusal to finish the task. It was testimony made through incompleteness. The parish register and the county roll, read together, form a pattern. The twins were entered only to be erased, recorded only to be skipped. Their existence was marked through absence, their presence seen most clearly in the spaces where they should have been. The official records, designed to preserve memory, instead became instruments of silence. The memorandum survives only by mention. It was drafted by a physician summoned to the estate, his handwriting trained to precision from years of clinical practice. The sheet was filled with observations written in even strokes, yet the paper itself never entered public record. Instead, it was folded, sealed with wax, and set aside. Where it should have been copied into the docket, the line remains blank. The omission carries more weight than any testimony the words themselves might have provided. The memorandum's absence did not pass unnoticed. Years later, when the physician's papers were inventoried after his death, the catalog lists missing memorandum, estate. No folio number is attached, no description survives. It is a record of something gone, an official acknowledgement that a document once existed but had been removed. Silence was preserved not by ignorance, but by recognition of what had been taken away. Archivists who reviewed the papers noted the care with which the physician had kept his files. Every consultation, every case, was numbered and bound. Only this memorandum breaks the pattern. Its absence is deliberate, a withholding rather than an accident. The gap in his orderly archive shows the choice of a man unwilling to place certain words into the hands of the court. The docket line itself is as telling as the missing sheet. Where his memorandum should have been cited, the entry is left vacant. The blank stands between other names and numbers, a space that calls attention to what is not there. That silence is as much a statement as the ink around it. It suggests that what he wrote was too dangerous, too incriminating to remain in open record. For the estate, the physician's silence became protection. No diagnosis, no testimony could be called upon in later years. The children existed in the ledger only through refusal. The sealed memorandum may once as. We have described their likeness, their condition, their resemblance too close to be ignored. But what survives is not description. It is the absence of description, preserved in catalog and docket alike. The estate's household accounts from the years following the twins' birth look ordinary at first glance. Columns of food, wages, tools, and seasonal repairs. Yet among the routine entries, a pattern emerges that unsettles the page. Laudanum appears in unusual quantities, purchased month after month, far beyond the needs of a single household. Payments to craftsmen for iron reinforcements recur steadily, their work described only as shutters secured or bars fitted. Alongside these, the salary of a private tutor rises far above parish standards. The accounts reveal a household turning inward, spending not to raise children, but to contain them. Medical tinctures dominate the ledgers where bread and flour once did. The bottles of laudanum are purchased in bulk, their costs climbing with each passing quarter. This was not the occasional remedy kept in a family cabinet, but a sustained reliance. The scale suggests attempts to suppress symptoms too severe for casual treatment. Each entry in neat ink marks another effort to quiet something that could not be managed openly. The records of building repairs show the same insistence on concealment. Carpenters are paid for their labor, but the descriptions point not to beautification, but confinement. Iron bars fixed to shutters, hinges reinforced, locks replaced in quick succession. The house was being altered into something less like a home and more like a holding space. These expenses, listed in dry columns, speak of architecture bent toward secrecy. The tutor's wages stand out most starkly. His pay exceeded that of parish masters responsible for dozens of children, though no evidence places him at the schoolhouse or in public examinations. Parish rosters list the children of other families, but never the twins. Their education was kept inside shuttered rooms, away from watchful eyes. The ledger shows the tutor as a man-pa, eyed to teach what could not be allowed beyond the estate's walls. Read together, the accounts give a portrait of a household both wealthy and sealed. Each coin was spent to maintain silence, through medicine, through reinforced windows, through private instruction removed from community oversight. The sums are steady, the handwriting calm, the ledger untroubled. Yet behind its order lies a history of concealment, where ordinary expenses became instruments of erasure. The cook's household notebook is not meant to hold history. It is filled mostly with kitchen tallies, shopping lists, and notes of what was served on which day. But midway through the year, her entries change. Names of servants appear in the margins with small crosses written beside them. These marks coincide with individuals who were never seen again. She wrote of staff who did not return after night duty, her quiet handwriting preserving what official payrolls refused to acknowledge. The payroll ledgers from the same period show no dismissals. Wages simply end without explanation. No reason is given, no transfer noted, no resignation entered. The absence itself becomes a kind of artifact. The cook's notebook, with its crosses beside vanished names, speaks more clearly than the estate's books of account. It is testimony made in private margins. Whispers among the servants began to circle around the same time. Another diary, kept by a laundress in town, records a troubling rumor carried from the estate. She wrote of the tutor, describing his pale demeanor and his claims of hearing two tones from one throat. He reported that when he taught lessons, voices overlapped in ways that unsettled him. This was never written in official reports, but the words survived in gossip preserved by another hand. The cook's notes show how silence spread within the household. She never elaborated on what happened to the servants marked with crosses, but her tallies continued as though nothing had changed. Bread measured, chickens accounted, yet the names of those who disappeared remained inked in her margins. Her notebook carries both routine and rupture, the steady rhythm of a kitchen overlaid by quiet signals of loss. When compared against estate accounts, the pattern becomes clear. Payments for food and wages shrink gradually, though the number of residents listed officially does not. The servants whose names were crossed out in the cook's notebook no longer appear in the payroll, but the ledgers frame this as nothing unusual. The contradiction between books is the only surviving evidence of what happened inside the estate walls. These fragments, crosses in a notebook, missing wages in accounts, rumors written in a laundress's diary, form the only testimony of that time. They do not accuse directly, but they do not allow silence either. Through these small records, the servant's unease is carried forward. The vestry minutes from that year contain an entry unlike the rest. Where the curate's name once stood, it has been struck through with a heavy smear of ink. The stroke is thick and deliberate, a blot that leaves no trace of the letters beneath. In the margin, a single word appears in another hand. Tacit, silent. The document does not explain, but the message is plain. His role in recording the banns was to be forgotten. The blot itself has weight. Vestry books usually preserve corrections neatly, with lines drawn through mistakes and initials set in the margin. But here there is only obliteration. The heavy ink turns a name into a dark smear, more forceful than a simple correction. It is a visual reminder that silence had been chosen as policy, and that even memory of the curate's act was not to remain. Parish registers from the following years show a steady decline in baptisms and marriages held at the estate chapel. Families who once brought children to its font began to travel to neighboring parishes. The numbers tell the story: fewer entries, longer gaps, until the chapel fell nearly unused. The avoidance was never explained in open record, but the statistical decline reveals a parish distancing itself from a place now shadowed by silence. The vestry minutes never openly condemn, but omission serves the same purpose. By blotting out a name and writing tacit, the parish instructed future generations to treat the matter as though it had not occurred. The Latin gave authority, formalizing silence into rule. The curate's role was removed not only from the present but from history itself. The records, read together, show how institutions preserved power by refusing to speak. Where the will had commanded, where the banns had disguised, the church now erased. Its book of minutes, intended to preserve memory, became a tool of forgetting. Through deliberate silence, the parish aligned itself with the estate, closing its records around what it would not acknowledge. The census sheet for that year preserves an anomaly as striking as any omission in parish or court. The estate is listed in detail, names of tenants, ages of servants, the siblings themselves recorded in orderly hand, yet where the twins should appear, there are only 2 heavy dashes. The enumerator, who copied each line in practiced script, left their identities unspoken. In a book designed to count every soul, they are rendered as absents. The handwriting of the enumerator shows no hesitation elsewhere. His letters are formed with confidence, numbers set neatly in columns, margins balanced, but the twins' line is marked by those dashes, thick and deliberate, as if drawn to catch the eye. The omission is not an error of memory or oversight. It is a chosen act, preserved in ink as clearly as any name. Official correspondence explains little. Within weeks of filing, the enumerator was reassigned to another district, leaving his route incomplete. No reason is given for the sudden change, but his departure ensured that no correction was made. The blank remained unfilled, the dashes left standing as the only trace of 2 children. Silence in bureaucracy is as permanent as silence in stone. Later tallies of the district population show the estate consistently undercounted. The numbers do not match the households described, yet no adjustment appears. Clerks repeated the same totals without questioning why 2 individuals had been left unnamed. The twins existed in the record only as subtraction, present by the measure of absence. The census, like the vestry minutes before it, became an instrument of silence. Its purpose was to preserve and count, yet it reduced 2 lives to marks of erasure. Read against the will, the banns, the chancery petition, and the midwife's ledger, the pattern is unmistakable. Each institution acknowledged the twins only by refusing to speak them into permanence. The inquest docket for that year opens with routine phrasing, the name of a missing field hand, the date of disappearance, the estate identified at the top margin. But where the second page should continue the record, there is only absence. The binding threads show where the sheet was torn away, leaving a gap that interrupts the testimony. What remains is not the evidence of inquiry, but the mark of removal. The word estate stands clear on the surviving page. Its presence indicates the origin of suspicion, but the narrative ends before witnesses could be recorded. Court protocol required testimonies to follow, yet none survive. Instead, the next entry in the docket belongs to an unrelated case filed weeks later. The absence does not hide the fact of inquiry. It highlights it. The space between one case and the next is a silence too deliberate to mistake. The docket bears a stamp, closed. The date attached to it falls within days of the initial entry, far faster than ordinary practice. Inquests rarely concluded so quickly. They required sworn testimony, examination of property, and deliberation. Here, none of those stages remain. The stamp affirms finality without showing process. It is closure without inquiry. Clerks who handled the docket made no effort to replace the missing page. Later catalogs mention the absence but offer no explanation. Page absent is the only note, a phrase repeated across inventories. It was acknowledgement without remedy, as if the system itself accepted the gap as permanent. What is gone is not forgotten. It is marked and preserved as absent. Family papers from the same season omit any mention of the inquest. Diaries, account books, and correspondence that usually tracked disputes are silent. The pattern repeats. What should be present is missing. What should be spoken is erased. Silence spread outward from the docket to private record, till the event existed only as a void between pages. The inquest, opened in form but closed in silence, left behind more absence than testimony. The missing page is not a blank error, it is evidence of deliberate removal. The docket shows how inquiry itself could be consumed by silence, reduced to a torn binding and a stamp of closure. The probate docket opens with familiar formality, pages of signatures, estate seals pressed deep into wax, and clerk's marginal notes of receipt. The uncle's will, long debated in private, moved through court without objection. The estate passed intact to the siblings, every acre and tithe secured under their joint name. No competing petitions were filed, no rival families appeared to challenge. Silence surrounded the transfer as thoroughly as ink framed the page. The absence of opposition is striking. Other households in the county had grounds to contest. Distant cousins, creditors, neighbors with adjoining claims, but none came forward. Probate usually stirred contention, yet here the papers advanced untouched. The record of silence became itself a testimony. Resistance had been pressed down before it could reach the court. Witnesses' names appear in the docket, parish leaders and county men who lent formality to the process. Their signatures remain, yet their recollections later told more than their pens allowed. Several described how curtains were drawn at the edge of the room, and behind them faint sounds betrayed the presence of the twins. They were said to be there, not in sight, but in shadow, concealed even at the moment their inheritance was confirmed. The estate was secured intact, fulfilling the will's demand for unity. The parchment proves that the siblings' union achieved what law and blood had bound together. Yet triumph was uneasy, marked by concealment. The heirs who justified the inheritance were hidden from view, as if their presence threatened the very legitimacy the court was enacting. Parish accounts after the probate echo the silence. No thanksgiving service is recorded, no formal blessing of the estate. In other cases, such ceremonies mark transition, yet here the church minutes fall quiet. The absence of ritual reinforced the unease, as if acnon, acknowledgement itself, would break the fragile arrangement. The probate records endure as a completed act, the estate fully passed and duly sealed. Yet when read beside private recollections, their formality reveals contradiction. Authority was affirmed, but behind curtains, silence was preserved. The estate's wealth and unity rested on concealment as much as on ink and seal. The parish minutes for that year preserve one of the clearest and most final acts of erasure. In the closing entry of the book, the clerk copied a line that reads, "All matters pertaining, struck and silent." The words were not surrounded by detail or explanation. They stood alone, set apart from the other business of the parish, which had been recorded in orderly lists of offerings, repairs, and seasonal observances. Where the estate was concerned, the instruction was simple: strike and silence. In the margin, written in darker ink and in another hand, appears a Latin phrase, recta, silentium. The word recta affirmed correctness, as if to justify what had been done, while silentium formalized the order. The choice of Latin gave the decision weight and permanence, placing it within the long tradition of church authority. It was not a note of hesitation, but of command. Later generations reading the page would find silence enshrined as the official record. The difference in ink tone suggests the margin note was added after the original entry, reinforcing it rather than contradicting. Parish clerks often used Latin to authenticate rulings, and here it served to cloak erasure in the language of law. By doing so, the church converted omission into doctrine. To remember was no longer permitted. To forget had been made correct. The consequences are visible in the years that follow. Parish registers contain no further mention of the estate's family. No marriages are solemnized, no baptisms recorded, no burials observed. The family ceased to exist within the life of the parish, their absence written into the continuity of the records. Other households are accounted for, their cycles of life and death carried forward in ink, while the estate's line disappears into official silence. Church books that should have preserved the family's presence instead document their era, sure. The combination of the stroke through ordinary business and the Latin note in the margin demonstrate a conscious choice. This was not neglect or oversight. It was instruction. Silence preserved as law. The estate, already shrouded in concealment, now vanished from the one institution that had authority to remember. The Church, by striking out and formalizing silence, ensured that the family's name would not endure even in ritual. Their existence, tied to inheritance and hidden behind curtains, was undone at the parish level. What remained was land, title, and wealth, but not presence in community or record. The estate auction catalog, drawn up after the siblings' deaths, lists their possessions in orderly sequence: bedsteads, tables, chairs, tools, and livestock. Each item is described with customary detail: dimensions, condition, sometimes even the craftsman's mark. But one entry breaks the pattern. A cedar chest is listed, with a single note beside it: contents undisclosed. No description of weight, fabric, or ornament follows. The omission stands out more sharply than any detail could. Auction catalogs were designed to reassure buyers. Transparency made goods easier to sell. Yet here, concealment was preserved in print. The chest was marked, acknowledged, but its secrecy carried forward even into public sale. The listing hints that silence was still required, even when possessions were being stripped from the estate. The buyer's diary offers the only surviving account of what happened next. In a plain entry written the night of the auction, he recorded that the chest was heavier than its size suggested, unnatural to the lift. He did not open it. Instead, he wrote that it was carried behind his house, set upon kindling, and burned until nothing remained. The words are brief but decisive, offering no explanation beyond unease. The destruction of the chest erased more than wood and metal. Whatever records, garments, or relics it contained were consumed with it. An entire history may have been lost in those flames. The diary marks the act not as curiosity, but as duty, as though the buyer felt compelled to destroy what others had chosen to conceal. His entry remains the only testimony, thin as it is, to the chest's existence and its end. Later attempts to trace the chest find nothing beyond that catalog entry and the diary note. No fragments, no mention of salvage, no recollection of resale. The silence that had surrounded the family in life extended into their be. Longings, consuming even what could have been preserved. The cedar chest, marked "Contents Undisclosed," survives only as absence, a line in a catalog, a brief note of burning, and nothing more. The auction, intended to disperse and preserve memory through objects, instead deepened the erasure. The chest became a symbol of deliberate destruction, secrecy carried forward into fire. What should have been evidence became rumor, what should have been artifact became ash. The tutor's diary, preserved only in fragments, offers the sole direct account of the twins. The small volume was found years later among scattered papers, its cover warped and its ink faded in places. One passage, however, remains sharp enough to read. The tutor wrote, "Two voices from the same throat, one higher, one lower." The line appears in the middle of a page, unframed by preface or context. It is a single observation set down with precision. As the entry continues, the handwriting begins to waver. Letters slope unevenly, strokes lose steadiness as though the writer's hand was unsettled by the act of recording. The sentence halts abruptly midway through a phrase. The pen trails into silence, leaving the page unfinished. No correction follows, no attempt to resume on the next line. The entry ends as suddenly as it began, an account cut short by reluctance or fear. Archivists who later examined the volume noted faint stains along the page. The marks did not obscure the words, but they drew the eye to the abruptness of the ending. The physical interruption reinforced the impression of unease. Scholars have long debated whether the stains were accidental or evidence of hesitation at the moment of writing. Whatever their origin, they leave the reader with a page that feels burdened as much by silence as by words. The phrase itself, "two voices from one throat," echoes rumors long carried in parish gossip and servant accounts. What had been whispered in kitchens and noted in ledgers found here a confirmation, however fragmentary. The tutor's words, set down in his own hand, align with recollections of "two tones in one room," reported years earlier. The diary thus bridges rumor with testimony, though it does so in the most unsettling brevity. No further entries appear in the diary after that page. The tutor had written regularly before, noting wages, lessons, and house hay, old routines. But the record ends there, at the description of the twins' voices. The silence that follows is as haunting as the words themselves. The absence of further notes turns the fragment into a kind of final statement. What was observed was not to be pursued again. The tutor's diary remains one of the few surviving personal accounts linked to the estate. It offers no explanation, no context, only the blunt line of description and the silence that swallows what follows. Read against the auction catalog, the church minutes, and the probate files, it becomes part of the same pattern. Testimony emerges only to be suppressed, voices only to be muted. The fragment endures as both record and omission, as much defined by what is unsaid as by what is written. The parish ledger closes the family's name with a mark more final than any word. A single crossbar stroke runs through the line, drawn heavier than the neat columns around it. The ink presses deep, cutting across the surname with a weight that clerks later described as uncommon. Where heirs should have been recorded beneath, the page is blank. The stroke stands in place of generations, ending the record with a single act of erasure. In most ledgers, names conclude with succession. Children appear beneath parents, heirs beneath households, each line extending the continuity of the parish. Here, no such listing follows. The absence is striking. The family that had been forced into prominence through will and court left no heirs to carry their name forward. What began with inheritance closed with a stroke of obliteration. The estate, once contested and consolidated, passed quietly to distant claimants. Papers record the transfer without fanfare, as if the family's presence had never truly belonged. The wealth endured, but the bloodline did not. The clerical mark in the ledger speaks more powerfully than any formal decree. Unity achieved through command could not sustain itself. Local memory preserved the family differently. Parishioners spoke of twins concealed, of children born deformed and hidden behind curtains. These whispers circulated long after the official records fell silent. Rumor outlived documentation, filling the space where testimony was struck away. The family's legacy became a tale told in fragments, half believed, half dreaded, carried not by ink but by voice. The crossbar stroke embodies the collapse of power into silence. The estate's line ended not with a name preserved, but with a mark of erasure. Its blunt weight reduced a household to rumor, transforming history into legend. The clerks who wrote the stroke could not have known that their mark would stand as the final testimony, but it remains the only one. What began with a will demanding a bloodline undivided concluded with a parish ledger refusing to list an heir. Between those two artifacts lies a story of power, concealment, and silence. The record closes not with continuity but with absence, leaving only the faint survival of whispers. If you wish to hear more accounts like this one, mark this record with a like and subscribe to our X archives so the next video won't get lost in time.